34. My lords, Constituent Assembly debates were referred to, but the page 21, PDF page 21, para 34. My lord, this CAD debate was not pointed out, my lords. This is in relation to Article 47 of the Directive Principles, my lords. And intoxicating liquor and intoxicating drinks have been interchangeably used, my lords. If my lords have it at the bottom where I've quoted, this is Honorable Shri B.G. Kher. He says, I do not wish to speak at length on prohibition because after very deliberate consideration and prolonged discussion, most of the provincial governments and most of those who are interested in the progress of this country have accepted the necessity of protecting our people from going to their ruin by the use of intoxicating drugs and liquor. My lords may note this word. The use of intoxicating drugs and liquors do not affect the moral sense of a person who uses them. Therefore, it is in the sense of beverage, my lords. Then, my lords may have on the next page, para 22, it continues, my lords. The very object of introducing the amendment, which I am very happy to find has been accepted by the Honorable Dr. Ambedkar, who is in charge of the bill, is to prevent the furtherance of vice. It is argued that the use of intoxicating liquors and induces drugs. So intoxicating liquor and intoxicating drink have been interchangeably used, my lords. This has also been noted by Mr. Sirvai in his book.
So liquor, intoxicating liquor and liquor has been used.
Yes, an intoxicating drink, when ultimately Article 47 came, it used the word intoxicating drinks. So intoxicating liquor has been used in that sense only, my lords. And Mr. Sirvai's quote has been already pointed out to my lords. And that's why I'm not repeating that. That is in paragraph 38 of my written submission, my lords. Now, my lords, directive principles, all the fields, my lords, have para 35 for a moment, my lords. The fields enumerated in the directive principles find place by and large in one or the other lists of the 7 schedule, my lords. Article 47, I have given Appendix 2, my lords, which this is at page 41 of the written submissions, my lords. This gives the comparison of which are articles and which is the legislative entry. But page para 20, para 35, read with Appendix 2. Right. That is at page 41, PDF page 41. My lords, the only thing one I would like to point out, the most important entry has been missed out in this appendix, my lords, which my lords may add at page 44, serial number 11. Entry 8 of list 2 has to be added in that, my lords. This has been missed out in the comparative chart appendix 2, my lords. Now coming back to
yes.
my lords, if alcohol, entry 8 talks about intoxicating liquor, my lords. If alcoholic liquor has to be added in that, it has to take color from the other entries in the same list, my lords. And I'm saying so because when the Law Commission report recommended that all alcohol be included in the state list, that was not accepted by the Parliament, and they restricted only potable alcohol, and non-potable alcohol was under the IDR, my lords. Therefore, they were very much conscious of the fact that state has only the power to the extent of potable alcohol and no further.
Yes. What is the next point?
My lords, next point is power to legislate on 245, 246.
So we'll take it as a second point.
Second point is the scope of 245, 246 and 254. This is at page 6 of my written submissions, my lords. Paragraph 4.
Can you tell us that again, please?
Paragraph 4, I have summarized 240. My lords may have 245 and 246 for a moment. Then I come to that, my lords.
What para?
Page? My lords, Constitution, my lords may have it.
Okay.
Article 245, 246.
So why don't you tell us what's
My
the point that you're making?
246, 1 and 2 starts with notwithstanding, that is non-obstante clause, and clause 3 of Article 246, subject to, my lords.
That's just
And this is the enabling provision to make laws. My lords, when we go to Article 254 for the repugnancy, it talks about laws made by the Parliament. So once the law has been made by the Parliament, then the test of repugnancy will take place vis-a-vis the state law, my lords. And if a law, Parliament has made the law, then to that extent, the state will be denuded of its power.
45.3, you're right, because we have discussed it. Yeah,
right, my lords.
What is the next point?
My lords, now here, once the field is occupied, my lords may have 162, Article 162 for a moment.
What's the point you're making?
My
That the
lords,
executive power of the state is coextensive with the legislature?
No, my lords, proviso to 162 is very important.
Yes.
May I read, my lords? Provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. In my humble submission, my lords, under the IDR Act, specific executive powers have been conferred on the central government, my lords. Like in 18G, it can notify, then there are other provisions. So once that power is there, the state is denuded of all its power, including legislative and executive power, to make laws in respect of IDR Act, my lords. The issues in this regard, my lords, there is one constitution-based decision, 2016, volume 7, SCC 1.
Where is it? Where do we find it in the compilation?
It is not in the, because it was last week.
What does it say?
I have given 2016, 7 SCC, page 1. Union of India versus, my lords, para 140. My lords may have it. I won't read the entire discussion, my lords. Para 140.
What is the point that you are stating?
My lords, the executive power under 162. Because my submission is the act has been enacted under the legislative power and the executive powers under the act have been conferred to the central government, my lords. Therefore, the state is denuded of its power even in respect of executive matters, my lords. My lords may have para 140 at page 117. Thirdly, my lords got it? Thirdly, a situation may arise where the authority to bring about a law may be available both to the union as well as the state, that the law made by the parliament may invest the executive power with the center, while the state may also enjoy similar such executive power by virtue of a law which the state legislature was also competent to make. In these situations, the ratio laid down by this court in the decision in so and so will have to be applied and ascertained which of the two, namely either the state or the union, would gain primacy to pass any order of remission, etc. In this context, it will be relevant to note the proviso to Article 162 of the Constitution, which reads as under. After the quotation, my lords, if the proviso applies to a case, the executive power of the state should yield to the executive power of the center expressly conferred by the Constitution or by any law made by Parliament upon the union or its authorities. Therefore, in my humble submission, the entire power, may be it legislative or executive, that has been taken away from the state by enacting IDR Act, my lords. The other relevant paragraph is 173.11. 173.11, where they have summarized, my lords. I'm not reading that, but this is the main.
But see, Article 73 proviso, huh?
Yes, my lords.
The proviso to Article 73.
73. It's quoted, my lords, in this. 73. Yes, my lords. 73 proviso. Provided that the executive power referred to in subclause A shall not, save as expressly provided in the Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws, subject to the laws made by the Parliament.
So, if it's a field in the concurrent list,
Yes.
Then even if it is a union law,
Yes, my
the state has the power, executive power, unless that law provides otherwise, expressly.
Expressly. And in my humble submission, the entire provisions, if my lord reads the entire act, the entire executive power has been vested in the central legislation. My lords may have sections 25 and 26 of the IDR Act for a moment. The other provisions.
This also we must also take into account,
yes, ma'am,
what is provided in the IDR Act,
yes, ma'am,
and what is specifically excluded out of the
yes,
IDR Act.
ma'am.
Now, when it says fermentation, and we have gone through it many times,
yes,
fermentation industries other than potable alcohol.
Yes.
So we must understand. I mean, that potable alcohol part would always remain with.
Yes, I'm not on that. I'm not on that. Potable alcohol is within the domain of the state legislature. I'm
saying that in the context of denatured spirit,
non-potable, my lords. Denatured is one of the species of non-potable, my lords.
Let's use the expression denatured spirit.
Yes, my lords.
In case of denatured spirit,
it is with the union.
The Union of India.
Yes.
That's the proposition that you are exposing.
I'm not restricting to denatured because non-potable is the correct phrase, my lord, because they've excluded potable. Potable means safe for drinking. The literal meaning of potable is safe for drinking. I don't have to go to any dictionary for that, my lords.
So are you saying that potable can be equated with the subject in entry 8?
8.
Intoxicating.
Intoxicating liquor. And that is why when it was recommended, Law Commission report recommended to include entire alcohol in the state list, entire alcohol outside the IDR Act, that was rejected by the Parliament.
Because intoxicating liquor within the meaning of entry 8 is for
beverage.
It's a
beverage purpose. I am obliged, my lord. So my lords may now have sections 25 and 26.
Liquor for industrial.
Which is
from section 25 and
section 25 is the delegation of powers. My lord, the center can delegate the power, and to that extent, my lords may have section 26 for a moment.
And directions.
Directions. And directions have been issued in the instant case, my lords, post 2016 amendment. My lords may have volume 4A, PDF page 489. In fact, I have quoted the relevant portion at page 48. Page 48, paragraph 26. Page 46. Para 48, page 24, my lords. Have my lords got it? Volume 4A, page 489. And the relevant portion has been quoted in my written submissions at page 26, para 48. Page, PDF page 26, para 48. That it is with the central government.
18D.
18G, G for
Yeah,
Goa.
yeah, that we have seen.
Yes.
Then your fourth point was section 25 and 26 of IDR
IDR
Act.
Act.
What is the next point?
My lords, next point is, my lords, we have the first schedule for a moment, my lords, of the IDR Act.
What is the
My lords,
formulated?
the product which are mentioned are in the exclusive domain of the central government, my lords. My lords, we have first schedule for a moment.
But there's no doubt about this.
My lords,
Exclusive domain.
my lords, give me 2 minutes. I'll explain what I have it in mind, my lords.
Just formulate the point and then tell us.
My lords, the first schedule opens with any industry engaged in the manufacture or production of any of the articles mentioned under each of the following heading or subheadings, namely. So any of the articles which are being manufactured will fall within the schedule industry. And 26 says fermentation industry other than potable alcohol, and the products are alcohol and other products of fermentation industry. So it is specific that non-potable alcohol is in the exclusive domain of the central government, my lords, union. Because the product as such has to be seen, not its ultimate use, or it can be diverted, or it can be used. The product which is being manufactured is non-potable alcohol, and it has to be seen as such, not its potentiality, my lords. Potential use is not the key test over here, my lords. It is the product which is being manufactured is the relevant factor.
Or potential misuse.
Use of, just a passing thought,
Yes,
use of beer
yes, my lord.
for washing your hair,
Yes, my lord.
will it be misuse or use?
My lord, it depends. If it is healthy, then it will be used. Because while washing, one can also have the beer as such, my lord. So it's both use and misuse.
Using beer shampoo is not intoxicating. I have
It's not.
So there will be use and abuse also.
My lord,
See, while making, they sort of, siphon off the intoxicating part of the product and was washed away.
well, as my learned colleague says, using beer for shampoo will not make it a beer as such, because then only beer is not there, something else added to the beer for using as a shampoo, my lords. It would not be.
So that this is the next products in the first schedule are in the exclusive domain of the central government,
Yes,
and
ma'am.
the opening words, any industry engaged in the manufacture or production of any article.
Because there are certain entries, my lords, where all the articles which are capable of being manufactured by the scheduled industry is not covered. Yes, my lords. My lords, may give me a moment, ma'am. My lords, the legislative history of IDR Act, because industrial alcohol has been loosely used, that was the argument. Industrial alcohol was in the original act, my lords, of 1951. My lords, I have given the compilation of the legislative history of IDR Act in volume 4F.
All right.
4F, my lords.
What else?
My lords, industrial alcohol, in power and industrial alcohol was in entry 24 at page 31 of the volume 4F.
All right, just 1 second. Let's go to that.
In fact, I have summarized in the list of dates in the opening page itself of 4F, my lords.
Volume 4F. Page.
Page 1 itself, my lords may have it, volume 4F. And the supporting documents are there, my lords. My lords, on 26th March 1949, when the bill was introduced, the draft entry was 18 in the first schedule, power and industrial alcohol. Then the 49 amendment bill came and the entry was 24, but it remained as power and industrial alcohol.
Mr. Agarwal, you're making an important point. Just let's quickly run through it. So 51.
51.
The bill was power and industrial
Alcohol. Then an amendment was made.
Before the amendment,
yes, ma'am.
Came the Act in 1951.
1951.
Where it was item 23, power and industrial alcohol.
Yes, my lords. At page 31.
Then came the
1956 bill, my lords. This is very important. 1956 bill, page 93 at 95.
And then entry
25 at page 98.
Became fermentation industry.
No, my lords, fermentation industry, and then 1 and 2, alcohol,
right.
dash industrial and power. my lords may note, this was in the bill. When it came to the Lok Sabha in debates, my lords, PDF page 152. Page 152. Right-hand side, my lords, right-hand side column, about 10 lines from the bottom, my lords. Page 8, have my lords got it? Page 8, right-hand side column of the Lok Sabha. 2. These were the amendments which were moved. PDF page 152. Sir, I beg to move to page 8, 2I, II. Line 12, omit industrial and power. So the amendment was made to remove industrial and power. And the reason was, this is intended to remove a printing error. My lords, page 152, right-hand side, towards the bottom, it says paragraph 2, 2I, II. In line 12, my lords, it starts, sir, I beg to move.
No,
Something.
No, my lords, page 152 of the PDF, my lords. PDF,
no, it starts with on the right-hand side, Industries, Development and
Regulation Act. Yes, my lords.
Is that
Then
what you
towards
said?
the bottom,
Bottom. Bottom continues in Hindi.
yes. Then thereafter,
So 154 we go to.
2 and II.
Just a minute.
PDF page 152. Printed page 149. Printed page 149 towards the right hand, about 8 lines from the bottom, my lords. II, line 12, omit
Industrial and power.
Oh, 149.
Or omit.
industrial and power. These are removed, and the reason for removal is, this is intended to remove a printing error.
What is the printing error?
That was industrial and power had to be removed, my lords. Only alcohol as a whole was to be there. The bill said alcohol dash industrial and power. So industrial and power has been removed and the entire alcohol was included, and that was the position till the 2016 amendment. This is how alcohol was introduced. So this alcohol meant both potable and non-potable.
2016 only alcohol.
In the original act, it was entry 23,
Yes, my lords.
which says power and industrial
Industrial
alcohol.
alcohol.
1 second,
Yes.
right? Then comes the 1956 amendment.
Meant,
It entry 26,
yes.
which is fermentation industries dash alcohol.
Fermentation industries, then 1 and 2. Yes, alcohol.
That is alcohol.
Alcohol.
And then 2016, it is entry 26 is substituted as fermentation industries other than potable.
Other than potable alcohol. So now it is restricted, and this is a retrospective amendment from the date of the act itself. So my learned friend, Mr. Datar said the amendment came in 56. So how can it be retrospective since 1953? So this is the legislative history and how it has been made retrospective from 1953.
Now, just 1 second, so that later on when we are dictating, we don't have to start hunting pages.
Yes.
1951.
Yes.
The original act.
Yes.
What is the PDF page in volume 4F? Just tell us.
4F. 4F. It is page 1 at 31. Page 36 at 42. Volume 4F, page 36, PDF page 36 at page 42.
All right. Then the 1956 amendment, we'll just look at it,
Yes.
you know, in a
Yes.
fraction of a moment.
Yes.
1956 amendment, where
Bill.
entry 56 comes. Don't forget the bill now.
Yes,
You
ma'am.
didn't even
Yes.
confuse ourselves with the
Yes,
bill.
it came from 1st March 1957.
What is the PDF page?
It is not, Act is not here, my lords. This.
All right, it's not there.
Yeah, okay.
Fermentation industries, bracket
And-
1, alcohol at the bottom. And then 2056, 2016, we of course have it,
Yes.
but give it to us again.
Yes, 2016 amendment is 4B, page 576.
Volume
4B, B for Bombay,
B for Mumbai.
B for Bangalore, Bangalore,
All right.
M for
volume
Mumbai.
4B,
B.
page.
page 576.
All right.
So, my lord, in my humble submission, potable alcohol as such is covered by, and the product which is manufactured from that industry has to be a non-potable alcohol. So, its use or misuse, my lords, will not determine the legislative power, my lords. My lords, I have given the, my lords, IDR Act is in in exercise of two legislative fields, my lords. One is entry 51 list, 52 list 1, and the second is entry 33A list 3, my lords. Entry,
What's the next point now?
my lords, I'm on that only. My lords, IDR Act is a complete code. Declaration is under section 2, which is deriving power from entry 52 list 1. Rest of the provisions of the Act derive their power from entry 33 list 3 of the Constitution, my lords. My lords, entry 33A, 33 says trade and commerce, supply, distribution, and production.
What's the point now?
My lord, so all these points have been covered. I am only pointing out Appendix 1, which I have in my written submissions, my lords.
Appendix 1 to your written submissions?
Written submissions.
What does it say?
I have tabulated which field is covered by which provision, my lords.
Which?
Which field under entry 33 is covered under which provision, my lords. PDF page 40.
Where will we get Appendix 1 page?
In my written submissions at page 40.
Which is
PDF
volume
page 40.
2E.
2E.
Let's go to that.
Page 40, my lords. So all the fields, legislative field under 33A is covered, my lords. I'm not going through the Act. From 1989, my lords.
Synthetics.
Synthetics. And the amendment has been effected in line with that, my lords.
1 second.
Synthetic is 1990.
1989 was the judgment,
And reported it.
reported in 1990.
All right, and last point.
My lords, and I have given the list of judgments, Appendix 4, which have followed synthetics, my lords.
1 second, let's make a note of that.
My lord, this is a classic case.
Appendix 4,
Page, I'll give my lords Appendix 4.
page 50.
Page. My lord, this is a classic case where the decision of this honorable court has been accepted by the government. Parliament has enacted a law in line with the decision of this honorable court. And the executive has also followed it, my lords. Apart from the various courts which have relied upon synthetics since the last 34 years.
Not classic case, rare case.
Rare case. This is the only case which I could find where the government has accepted the
All
judgment.
right, what last point?
Yes. My lord, there were two arguments made by the other side. One by Mr. Jaideep Gupta for State of Bengal, that there would be an administrative chaos. My lord, administrative chaos cannot be a ground to justify whether the legislative competence, my lords. There is a sentence in the judgment of this honorable court in B. Prabhakar Rao, my lords. When you have stirred the hornet's nest, you should be ready to kill this thing. My lords, if my lords want, I can give the citation. I'm not reading that, my lords. That is 1985 Supplement SCC 432, para 20 at 462.
Supplementary 4 SCC.
Supplementary SCC 432. At that time, there was only one supplementary volume.
And para?
Para 20 at 462, quoting Lord Dainik, my lords. And then this was later relied on 2014, 4 SCC 720, para 70.
2014, 4 SCC.
CC 720, para 70.
The earlier judgment, is it in the compilation?
No, it's not. It's
Second
not.
one also is not.
I'll give.
All right, thank you, Mr.
My
Agarwal.
lords, one more thing. My lords, Mr. Balbir Singh, while appearing for Maharashtra, said we are following BIS standards of denaturance, my lords. My client used BIS standard and is being prosecuted because they say it is our standards which have to be taken and not BIS standard, my lords.
Thank you, Mr.
DPO.
You are satisfied now that you've given me a full hearing?
My lord,
Thank you.
the only thing is, my
I
lord,
must compliment you. You are also very precise and absolutely on the point. So we
my
appreciate.
lord,
Thank
I
you.
may be permitted to file a 2-page.
No, now don't file 2 pages. Now you've filed so many pages before.
Deeply of that.
Yes, Mr. Bhandari.
Well, I'm only going to take 5 to 7 minutes. I filed a very short note, which is at volume 2H. So, Millards, my other submission can be ignored because it will be repetitive to what others have filed. So, I filed now 2H, Millards, which is a very short note. Volume 2H.
Volume
2H.
In fact, my lord, my lord, for alcohol, one I had already told my lord, the Chief Justice, about Mr. Nariman, my lord, but the most oft-quoted couplet in Urdu about alcohol is that, Zahid means, the cleric means, and it said, Zahid sharab peene de masjid mein baith kar, ya wo jagah bata de jahan par khuda na.
Beautiful.
Millards, my first argument is that the decision of Bombay High Court in Balsara is the right decision and gives the correct interpretation to the term intoxicating liquor. And that's para A of my note. Bombay High Court reasons this in about 4 or 5 or 6 lines. And I've quoted that exact paragraph. If my lords looks, my lords, it says in the first instance, liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Now, the other side wants to argue that the term liquor comes from liqueur, and therefore please extend it to also include liquids. But if one looks at the Constitution itself, the Constitution in entry 53 list 1 uses the word liquids. So liquor and liquids cannot be interchanged.
Where does the Constitution use? Yes, of course.
Yes. At entry 53 list 1, liquids is a term used in a non-consumption manner. So therefore, to extend liquor to mean liquids, the answer is in the Constitution itself, because Constitution uses the word liquids when it wants to use the word liquids. That's at entry 53 list 1. So as far as liquor's definition given in Balsara's High Court judgment, meaning a strong drink, that's the correct one. Then second reason why Balsara High Court states that it's for human consumption is because then it goes on to define what is the meaning of the term intoxication. And it says, very interestingly, in the second place, the use of the word intoxicating in item number 31 in contradistinction to the use of the word alcoholic in item number 40A as qualifying the word liquor is very significant. We may also point out that in the white paper, item 26, which corresponded to entry 31, used the word alcoholic liquors, which have in Government of India Act been changed into intoxicating liquors. Therefore, it is apparent that from the class of alcoholic drinks, non-intoxicating drinks are excluded by this entry. Thirdly, medicinal and toilet preparations containing alcohol which are found in entry 46 are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item number 31. So, my lords, there it reaches the conclusion why intoxicating should be something for human consumption. My lords, then if one steps back and looks at Article 47, why is entry 8 worded in the way it is worded? If one looks at entry 25, one will see that when they wanted to do gas and gas works, they said gas and gas works full stop. But when they drafted entry 8, they gave it with full splendor. That is to say production, manufacture, supply. That is because if one steps back and looks what the state is vested with, the state is vested with every power to achieve and fulfill what Article 47 Directive Principle mandates it to do. Therefore, entry 8 had all these words to ensure that if state wants to fulfill its objective under 47, it can do that and has enough powers there. That's why entry 6 also public sanitation is with the state. And more importantly, entry 51 list 2 gives state full power to levy excise duty on potable alcohol. So this all flows from 47, because to achieve the purpose in 47, entry 6 public health and sanitation, entry 51 tax on excise duty, and lastly but not least, entry 8 list 2, which is that is to say production, manufacture, supply, everything is vested as far as potable alcohol is concerned with the state, so that it can fulfill its objectives under Article 47. So my humble submission is that the definition of intoxicating liquors, one can see what it means by looking at the Constitution itself. Then, my lords, I cite after that, there was an argument made that if you look at the Indian Government Act of 1935, and you look at the local acts in and around that period, then intoxicating liquor, especially liquor, could mean liquids also. But my lords, the only point I'm making here is that even under the Indian Government Act, there was a Power Alcohol Act of 1948, which Synthetics 2 has looked at, and therefore that, so from those days itself, industrial alcohol is within the center's control. Now, my lords, para 2 of my note, my lords, I have actually set out where all the term intoxicating is used in the Constitution. It's very interesting. Article 47, then there is Article 366(29)AF, and then there is Schedule 7, Entry 8. All these three places where the term intoxicating is used is in connotation for human consumption. There is one more place which my note left out, my lords, which is Schedule 6 of Entry 3B, which deals with special laws for Bodo land. There also it's for human consumption.
Just 1 second.
But that's para 2 of my note.
In Article 47, Article 366,
29AF.
and Entry 8.
Yes.
And which was the final
And
one?
then, my lords, one final which is left out is Schedule 6, Entry 3B. The Constitution. All, my lords, are in the context of something which can be consumed. So intoxicating has never been used in the Constitution in the context cannot be consumed or not fit for human consumption. So, my lords, that's as far as intoxicating liquor is concerned. Now, my lords, the second point I want to make is, my lords, I feel, my lords, the case of Tilak Ram was dealt with. What was not dealt with in reply, I suppose, was the Calcutta Gas Company case, which follows Tilak Ram. Now, Calcutta Gas Company case, my lords, I don't need to go as far as saying, please overrule these judgments. Tikaram, I'm sorry. Calcutta Gas Company case, I don't need to go as far to say, please overrule Calcutta Gas Company to make me reach where I want to reach. According to me, if one looks at Calcutta Gas Company case and looks at the reasoning of Calcutta Gas Company case, it supports me because the way they dealt with the analysis, if that same analysis is applied, then entry 8 would exclude industrial alcohol. And I've cited a very interesting paragraph from Calcutta Gas, which was the key paragraph, where Calcutta Gas was trying to look at entry 25, which said gas and gas.
That para 9 that you quoted page
Yes, I've quoted. Yes, from para 6, I've quoted it, and I've quoted para 9 of the judgment. There's a second page of the quotation of the judgment where I've underlined in bold. There, the point I'm making is that if one looks at the court was confronted with entry 25, which says gas and gas works, and the court was then confronted with entry 24, industries. Court said, if I say that gas and gas works is in 24, then of course it will fall into 52, and therefore I will entry 25 will be left meaningless. Rather, the way court was at a situation where it says, and I'll read this just 4 lines. It's from what I've highlighted and underlined is 3 lines above that. If industry entry 24 is interpreted to include gas and gas works, entry 25 may become redundant. And in the context of the succeeding entries, namely entry 26 dealing with trade and commerce and entry 27 dealing with production, supply and distributions of goods, it will be deprived of all its contents and reduced to useless lumber. Because my humble submission is that by removing industrial alcohol from entry 2, one would not make entry 8 useless lumber. Entry 8 would still apply fully as far as potable alcohol is concerned. Here was a case where the court was trying to see what would be left with gas and gas works if I put it the entire thing in the industry. So, Millards, if that analysis is also applied, then Millards, Calcutta Gas comes to my rescue. Leaving Millards to my last point, which I've made, Millards, at para 9 of my note, is that Synthetics 2 cites India Mica's case and says that within the parameters of India Mica case, if a regulatory fee is imposed by the state, and those parameters and the boundaries are set out in India Mica's case, which is time tested and recently applied in Vama Organics 2, which was read out by Honorable Solicitor General. So, Millards, as far as regulatory fee imposition is concerned, Synthetics 2 also leaves that door open for the state. So, according to me, it's a storm in a teacup, Millards, to say that we can't do anything. If you fall within the parameters of India Mica case, you can still impose a regulatory fee. Those are my points. I'm very good.
Yes, Mr. Yes, Mr.
A very, very short compass. My submission would be only on the phrase this alcoholic liquor for human consumption. Although lordships are looking at entry 8, the intoxicating liquor, my submissions are just twofold. The phrase alcoholic liquor for human consumption has since been long, since the Constitution has been understood as what the synthetics has said, which is to be consumed as it is. The debate has always been with regard to intoxicating liquor and the fact that whether the something other than alcoholic liquor for human consumption will also be added in intoxicating liquor. So far as there's submissions to say that alcoholic liquor for human consumption has to be expanded to mean something capable of also has never been the any judgments of a lordship, except the Bihar distillery, which makes a aberration in that to say that now you can even go and impose excise duty with regard to rectified spirit, etc., which is not a alcoholic liquor for human consumption. So my submission to your lordships is that with regard to this phrase alcoholic liquor for human consumption, since Balsara and till Synthetics 2 and the later judgments, all have consistently as held that this phrase would mean only with something which can be consumed as it is. Whether intoxicating liquor, as what has been all argued, will also include something else, but the Lordships will see, I would not wish to make those submissions on that. My only submission, I have put that how it has been followed till Utkal Distilleries, this 2022 judgment of a Lordships, all have taken this consistent view except the judgment in Bihar Distillery. Now, Bihar Distillery, Lordships may just note the fact that it applies a very simple test, which according to me it's not correct, is the fact that it's a case of a mere dilution. In fact, it also recognizes the fact that it makes a potable alcohol or alcohol for human consumption only when you dilute it. So therefore, they imply there is an existence of a process, and the initial, that is a rectified spirit, is not something which is alcoholic for human consumption. So my submission to your Lordships is, one, the test that it is a case of mere dilution is not correct, as a Lordships in Winbros, in the case of an income tax, has clearly analyzed the process and has said that it is not only a mere dilution, it has to be a case where it has to be put on a specific environment, on a temperature, by addition of many other things to make it fit for human consumption. So my submission to your Lordships.
Given us a note by any chance?
Yes, your Lordships, it's 2J, volume 2J.
All right.
Yes, your Lordships. And one last submission to your Lordships consideration. There was a submission made that, look, today, after a GST, what the states have been left with is the entry 54 is the alcohol liquor for human consumption. And then your Lordship has to read it expansively. My submission to that is that, in fact, if that has been the interpretation given, there would be a substantial loss, because today, post GST, all other alcoholic liquor, including the rectified spirit and the extra neutral alcohol, all is liable for GST. So that GST also goes to state. It's not only that the center is keeping, as Lordships know, so it's a federal fiscal legislation. So it goes both to states and the center. Now, apart from that, for alcohol liquor for human consumption, they have an exclusive power to impose sales tax. So my submission is that what they are losing would be, in fact, a GST in case if the expansive meaning is to be given, not there has been a loss to a revenue, because that's what Shadan.
Thank you, Mr. Pawanchal. Yes.
May it please, Lords. Blood, small submission, blood, for 5 minutes, I'll take it. Blood, 901.16, SLP civil number 3160 of 2015. Blood, this SLP, blood, subject to outcome of your Lordship decision, this is to be decided. Blood, on the ground, blood, certain duty was imposed.
But what, we'll not go into the facts. You can tell us what your submission on law.
Blood, my submission is, they have imposed a certain interest, blood, for the duty because of the issue.
That
Blood,
will have to go before the regular.
blood, the Honorable High Court.
You have to say on the questions which we have been hearing on arguments on now for the last several days.
Yes, my lord. In case if your Lordship is upholding the judgment, my lord, I got benefited this respondent. Suppose overruling it, my lord, the
That's
interest should not 100%,
That you can argue. before.
180% it is coming, my lord.
All
Actually, more than a crore.
Yes, all right. Thank you.
Much of.
But Rampurchini, just 2 minutes, your Lordship, just stepping back. Now it has become a center versus state issue, which is rightly so. But it started out as me or the private party versus the state issue. And the legislation in question was the UP Excise Act, in light of which, and why we say it, because in light of the 3 issues which are before the court. The first issue is regarding entry 84 list 1 and the counterpart entry, which is entry 51 list 2. The issue regarding that is alcohol fit for human consumption. The second issue is regarding entry 8 list 2, which is intoxicating liquor. And the third issue is regarding entry 33 of list 3, which is to be, as per the other side, read along with entry 24 of list 2, which is on the industries aspect. And the counterpart entry in entry 52 list 1.
What do you have to add?
The only thing add is, your Lordship, in the UP Excise Act, we have to see the legislative conscious from the act itself. If your Lordship will see the act, because no one has shown the act itself defines what a liquor is. The UP state says liquor is intoxicating liquor, and in what it includes, they add all the beverages. So the argument sought to be made now is contrary to the legislative conscience itself. If your lordship takes the statute for 1 minute,
Where do we get it? We just make a note and then.
your lordship, it's in volume 4, page number 682. There are 4 definitions which are important in this statute. The first is excise duty, which is at page 692. Because it says excise duty as per entry 51, list 2.
All right, excise duty in 692.
Then definition of liquor, which is also at page 692, bottom, your lordship. I'll just read it out. It says liquor means intoxicating liquor and includes spirits of wine, spirit, curry, panchai, beer, and all liquids consisting of and containing of alcohol. So there is no question of moving beyond these beverages or taking assistance of entry 8. The other is excisable articles, which is definition at page 696. Excisable article, they specifically mention, means any alcoholic liquor for human consumption.
Yes.
And then, your lordship, section 13, read with section 19 and 28 of the Act, says that any transport or removal of these excisable article, that is to say any alcoholic liquor fit for human consumption, will be charged with a duty. So they, in the legislative aspect, have only relied on entry 51, which as per every submission is barred by entry 82.
Thank you.
Entry 84.
Yes, Mr. Dwivedi.
I was to answer, my lord, that Tikaramji issue, my lord, if your lordships recollects, whether it is, my lord, my submission is this, my lords. Lord, Tikaramji essentially does 3 things. A, it compares the 2 acts which were in question in that petition and says that there is no repugnancy in that matter, with which, my lord, we are not concerned.
Yes.
But second, which in my submission is an obiter because that was not required to be decided, is the term industry in entry 52 list 1 is restricted only to manufacture, neither pre nor post manufacture. And third, Tikaramji does not even go into occupied field and says that once there is no notified order, the scope is open for the state to step in and legislate.
Does not go into occupied.
Does not go into it and says that, but that is clearly an obiter. It was not required to be decided. There is no discussion why one view over another view. So it is an obiter. But so far as second issue is concerned,
yes,
regarding the restricted meaning given to the term industry, but there are some legislations in place as on date referable to entry 52 list 1. So they might be impacted. In future, the parliament may require, my lord, in peculiar circumstances, to control, my lord, right from raw material till the end product's usage. So, my lord, I am not, my lord, respectfully, my lord, concerned with whether Tikaramji is overruled, affirmed, or explained, my lord. That's entirely your lordship's prerogative. But, my lord, kindly bear these factors in mind. So far as second is concerned, whichever way, your lordships may, my lord, accept our submission that there was no legal or other necessity to restrict the meaning of the term industry. it is wide meaning. And if it is not so, then even entry 24 list 2 also will be impacted. Because then state also will have only manufacturing part. So I'm not, my lord, against state. I'm saying state also would be adversely affected.
Thank you.
So these are my assumptions.
Good night. Yes, Mr. Dwivedi.
Wait, please. We have compiled the rejoinder submissions also for lordship's convenience. The short 10 pages only, 15 pages.
Where will you find it, Mr. Dwivedi? The
Volume 1M.
this.
It's on the screen. No?
DG code.
Yes, sir. Then you can scroll.
That's digital PC.
Digital PC.
Yes.
Then you can scroll it out. Yes.
Digital mode. Law, as I have been taught, and as I have learned over the years, and your lordships have hammered it in, and that is, Lord, we are a federal structure. But the power of the state under list 2 cannot be controlled or regulated by parliament. That's the concept of cooperative federalism. Federalism, your lordships have churned out, Lord, time and again. And if I would refer to your lordship's judgment, 2000.
Would you like to read that out? We have that para 1, para A. Let's see how you have formulated it.
No, I was responding to what was argued today.
Right at the end. Sorry.
So the question is not, what we are being told is that in 1951, IDR contained industry and industrial alcohol and other things. In 56, it was modified to include alcohol under the heading fermentation. And then 16, again, it has been changed. Now I ask myself, is the jurisdiction of the state going to conform to the law laid down by the parliament? Or can parliament, by constantly modifying and amending its own act law, dictate what is contained in the state list? Lordships have very clearly said state list reserved for the states, and states have plenary power, which power cannot be controlled by parliament or by parliamentary legislation. That's not is absolutely clear. But yet my friends say that entry 8 has to be guided by legislation of parliament, 1951 Act. Now I ask myself, Lord, what is being argued in fact is that forget what the makers of Government of India Act 1935 had in mind when they incorporated entry 31, which is the same, verbatim the same as entry 8. What they had in mind when they incorporated entry 40, which is excise duty, same as entry 51, list 2. My friends further say, forget what the framers of the Constitution saw in the Government of India Act and these entries and incorporated that verbatim in the same manner as in the Government of India Act. My friends further forget the fact that the legislative history, if these Government of India Act and the Constitution entries are seen in the light of the legislative history contained both the things in the same manner as incorporated in the term intoxicating liquor in entry 31 of the Government of India Act. So what we really have to see is, what did the makers of the Government of India Act have in mind when they incorporated entry 31, list 2? That is intoxicating liquor and in all its facets. And not anything else. No. The parliamentary law may say whatever it wants to, parliament may include whatever it wants to, but we cannot on the ground of parliamentary supremacy justify this kind of encroachment on the state list.
So therefore, what is absolutely essential is that before we go into the issue, whether intoxicating liquor means what I am claiming or what they are, or it means what they are claiming. No? Before that, we must be clear about the federal aspect that is embedded in our constitution. And the best judgment in that regard, not the latest one, I would submit Lordship's judgment for 2018, 8 SCC 501. That is at volume 5, PDF page 1299. The relevant paragraphs note I have given my note
Volume.
at page 1.
Volume 8.
The emphasis is quite clear and unequivocal that state powers are plenary within their own list. They cannot be tempered by parliament. Now, what are being
You are supposed to give your rejoinder today, right?
Ma'am.
But why this particular document is uploaded during the court hours? We are having to stress our hand
quite
and get away from the notes that we are taking with our hands. It should have been incorporated before we commence proceedings.
So we can keep a mouse here.
To the technical issue
Yes.
and what we are having to concentrate on the
Right.
law is getting diverted.
Right. No,
I mean, at least I'm speaking for myself. I'm not speaking for other members of the bench.
I can understand that difficulty, because since we are confining ourselves to this technology part, we can't. Obviously, there's no.
So if it was done at 10 o'clock, it would have been incorporated in our devices.
I think
Was it 9:45, my lords? Was it 9:45?
Why not at yesterday evening? Why not today at 6 o'clock? Don't try to give a justification 9:45. 9:45, we are getting dressed for court.
quite right.
9:45, what do you do, if I may ask you, young man?
Where is it coming to the?
My apology, ma'am.
You are looking at your, preparation of the court, or you are getting dressed for the court? I think we have the same routine.
My extreme apologies.
No, it's
I
just
should-
that I am a little disturbed. That's all. Everybody.
It's inconvenient and difficult too, but I can understand. Yes. Cooler. Yes. Or if I may enlighten the entire this was the evening whiskey which caused the problem. But my apologies, Lord, Lordship may. My extreme apologies, Lord.
It from you.
Yes, Mr. Dedi.
I was just to
Right.
enlighten the entire thing.
Yes, Mr. Dedi.
Now, Lord, therefore, what I was saying is, Lord, what we have to look into is what does the Constitution provide, not what does the law provide of Parliament. Parliament would always be encroaching. The nature of power is encroaching, and they therefore always try to encroach. Now, that is why I was referring to 2018, volume 8, FCC 501, paragraphs 94 to 120, 123 to 133, 466 to 468. And then, Lord, that 9 judges judgment, Lord, of Jindal, in which Lord Justice Chandrachud was there, Lord. 2017, volume 2, SCC 1, volume 12, paras 13 to 16. This is PDF page 678. PDF page 678. PDF page 678, volume 5. Now, Lord, if I may, Lord, Lordship, since Lordship, I have it here, can I place the A part of my?
Yes.
The words notwithstanding clause 2 and 3 and subject to in Article 246(3) are not unlimited. They are limited by the context, that is the basic structure of the dual polity. Admittedly, both the union and the state legislatures are plenary in relation to their fields. Both derive equal powers of legislation only from the Constitution. The states share sovereignty with the union, and that they are legislative plenipotentiates within their legislative fields. They are neither appendages nor satellites of the union, but are its co-equal. This is precisely what Lordships have said in 2018, following large number of decisions in the earlier. Therefore, keeping in the context in view, we have to analyze the scope of the aforesaid phrases. The issue of parliamentary supremacy arises only in the event of a conflict of entries. Can you note this one? It arises only in the event of a conflict of entries under 3 lists, and not in the case of conflict of laws that attracts question of repugnancy or occupied field. Not only the entries in the union list, but all the legislative entries in the other lists are to be interpreted widely and liberally. While so interpreted, conflicts or overlaps may arise, which are resolved as per the principles evolved in Ext Pharmaceuticals note. And I have, for Lordship's convenience, note, laid down certain paragraphs which are relevant. In fact, this judgment, Lord, Ext Pharmaceutical, which is kind of an authority for this purpose. It in fact says if there is a conflict between the entry in the list 1 and entry in the list 3 and 2, sorry, then the effort has to be to reconcile the conflict harmoniously. And every effort should be made to reconcile harmoniously. It is only when no reconciliation under any circumstance is possible, then only then this parliamentary supremacy kicks in. But then for that purpose, they went to this extent, Lord, that if the central list is a general list, that's what is considered in this thing. And if the state list overlaps the central list, then carve out a space for the state list, and then create whatever normally could be given to the center and appropriate space for the state. It's not that we will wipe out the state entry because there is a conflict. So this kind of interpretation has been followed by our lordships all throughout, and I'll show it till about 2002 ITC. The parliamentary supremacy as held in the above case is limited and not absolute. It operates only when there is a irreconcilable conflict of entries. The irreconcilable conflict will only emerge when all efforts at harmonious reconciliation fail. One of the foremost methods of reconciliation, as pointed out, is to cut down the union entry and carve out a reasonable space for the state entry.
Given the provision list 1 and respects poisons and dangerous drugs provisions. So up to liquor is
intoxicating liquor, that is to say.
The Lordship now compares right from opium to the end, all the other words are given.
Spirit, wine, spirit, and all liquids consisting of or containing alcohol. Spirit is defined to mean all liquids containing alcohol, indicated in Gannon Dunkerley, though it did not notice that judgment, but verbatim the same situation.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको